Hi, my name is Cullen, and I'm a personal injury attorney in Winter Park, Florida. We talk to a lot of people who have been involved in car accidents, and sometimes, in fact it's very rarely nowadays, but sometimes we talk to people who are concerned because they weren't wearing their seatbelts at the time of their accident. So a lot of those folks have concerns about, whether they have a case, or do I have a case if I wasn't wearing my seatbelt at the time of the accident? The quick answer to the question is probably, but I need to explain. There used to be a very complicated legal defense that defendants in car accident cases would mount involving the use or failure to use a seatbelt. But beginning in 1996, the rules regarding the seatbelt defense changed. And so now all of the seatbelt defense is combined or subsumed into the general defense of comparative negligence. And for those of you that have watched our previous video on comparative negligence, you know that in Florida, juries are asked to compare the negligence of anyone who was allegedly responsible for causing or contributing to injuries or the accident, and then weighing all those against each other until the jury finds 100% fault. And it could be 50% one person, 50% another, or 25, 25, 25, 25. It really doesn't matter. In the seatbelt defense, though, it's now just part of comparative negligence against the injured person. So conceivably, a jury would look at a wide variety of issues regarding the injured person. For example, did they ride in a car that didn't have operational seatbelts? I guess the jury could say that the person shouldn't have ridden in a car that didn't have operational seatbelts. Or did the person ride in a car that was transporting 7 or 8 people so that everybody in the car didn't have their own seatbelt? A jury might also look at, well, was it reasonable that the person wasn't wearing a seatbelt? For example, was the seatbelt broken? Or was the injured person pregnant? Or was there some other physical reason where they already injured so that they couldn't wear a seatbelt? Those would all be issues that might weigh against or in favor of the injured person. And then the second issue that a jury would have to decide is, even if the plaintiff or the injured person was comparatively negligent, did that comparative negligence contribute to the person's injuries? So for example, a classic example of this might be a person who didn't wear their seatbelt, was ejected from the vehicle, fell into or flew into a pond and drowned. Well, clearly that would be evidence that the person's negligence contributed to the ultimate result or injury. In a garden variety personal injury case, it's not going to be nearly as clear. For example, if a person was involved in a car accident and is now complaining of neck or back pain, then it would be our position that the defense would be under the burden of proving that the plaintiff's injuries were made worse or made different because they weren't wearing a seatbelt. Otherwise, if they can't prove that not wearing a seatbelt contributed to the injury, then there's no way that the injured person can be held responsible for causing those injuries. So as you can see, the seatbelt defense is pretty fact specific, so it's going to differ from case to case to case. So if you have any questions about whether the seatbelt defense might apply to your case, or if you didn't wear your seatbelt in an accident and you're worried about whether you have a case at all, please reach out to us. We love to answer questions. All you have to do is call our office at 407-254-4901. You can text us at 407-644-4444, or you can even reach us through the Facebook Messenger app.